settlement docs, we can submit both and they both will be paid at the same time.
That was in the 243rd, right?
Yes,
There
that
was a
other,
summary judgment, and that notice of judgment was sent on September 15th. Am I looking at Wells Fargo Bank versus Carmen Chavez?
yes, that's the wife of the case that we have today. And we're waiting on documents from the same law firm for that settlement. So we can submit both is what's going on.
That case has been disposed of. Like, how are you all doing that? Help me understand. It was disposed of on September 11th.
Yeah, from what I'm told from the other side in communication this morning is that we're still waiting on settlement documents for that case as well. This is the information that I was given this morning.
This case is being set for a dismissal hearing in 2 weeks.
Could we set it for trial in 90 days? Could that give us more time?
I'm setting it for a dismissal hearing in 2 weeks.
And can you help me explain, Your Honor, because I have to get back to the parties that be on what's going on. Like
You're telling me my case is pending because there is another case pending, and that case is not pending. That's why.
So instead of a dismissal hearing, because I don't want to do this to the plaintiff, obviously, because I don't want to dismiss their case, could we just set up for trial in a longer period of time, which would give us
No.
time to get the
You
settlement
have a
document?
trial in 2 weeks.
Your Honor, I'm just trying to understand what the rush is here. We have it settled. I just have an administrative hurdle. I'm just trying to get over if I can get some help from the court.
So you've told me something that appears to be inaccurate, right? About the other case, right?
I'm just giving you the best information that I have, Your Honor. It's just, I have three people I'm trying to make happy here. I'm trying to make the court happy, I'm trying to make the clients happy, I'm trying to make the opposing party happy. I'm just seeing if anybody will work with me. And hopefully, if the Wells Fargo and the other law firm can get me the documents in 2 weeks, then great. I'm happy to get everything signed and get this done. I want to get it done just like you want to get it done.
Yeah, we'll see you in 2 weeks. Thank you.
Sure.
Your Honor, I guess, just in abundance of caution, can we have 4 weeks?
I'm setting it for a dismissal hearing in 2 weeks, okay?
Understood.
Thank you very much. Y'all are excused. Who's next?
Judge, starting on page 1, calling cause number 2023 DCV 4430 Alejandra Diaz et al. Versus Maria de la Carmen Esparza et al. Announcements, please.
Manny Morga for plaintiff, Your Honor.
Good morning,
Mariana
Your Honor.
Perez,
Soraya
for
Llenar Hanshu ad litem.
Ms. Henshu, and then what was the other announcement?
Ariana Perez for defendant Maria Carmen Esparza.
Okay. Again, another entry of judgment. This was a 1 week or two. How did you all clear up all the amounts and all of those wonderful things, or was there anything else outstanding?
Your Honor, Mr. Kennedy's office did bring me a check.
Mhm.
So we've moved at least in the right direction with one party. So I now have his contribution to the ad litems total. I'm still waiting on all checks from both defendants, from Mr. Paxson and Ms. Bettis. They've both indicated that those checks are being cut. I don't have anything yet.
Okay.
Your Honor, yeah, payment on behalf of our client was sent about over a month ago to Ms. Hanshu, so she has the check for both the minors. I did confirm with Ms. Hanshu that her ad litem fee has been sent. There was a change in the fee, and so we had to cancel the first payment and reissue the new payment. And that has already been confirmed with Ms. Hanshu. However, the checks were not overnighted, which is why she does not have them yet. She should have them by this Friday, but the payment for the minors are already in possession of Ms. Hanshu.
We're still missing payment from Mr. Paxson, Your Honor, for his portion of the ad litem fee as well as his portion of the minors total going to the district clerk.
So, I mean, we're gonna have to have a hearing on this because I'm literally hearing, other than the ad litem fee, which I understand that part. The payout, we're not on the same page. We're not on the same page.
Mr. Paxton claims it's been cut, and he called me yesterday to apologize, to tell me the same. But I do think we probably have to reset, only, Your Honor, because I've been told that before, and I mean, we finalized this in August. It's
Mhm.
November. I'm still sitting with it on my desk.
Yeah, yeah. Okay, so, yeah, we're gonna have to have a hearing. Now, in light of the holidays, we're probably looking now at like December 3rd, right? Am I correct on that? Let me see, 19th, yep. December 3rd at 9:30. How about we do it in person? I'm sorry, 9 a.m.
Your Honor, if I get the checks and I have everything I need, then I will inform the court before that so as to not waste the court's time. And I'll close it out once I have everything. If I don't, then I'll see you then at 9.
See everybody then. Thank you so much.
Thank you so much, Judge. I appreciate it. Have a good day.
Bye-bye.
All right. Where are we headed next? I see we have a few that were reset, dismissed.
Yes, ma'am. 0259 was reset for tomorrow. 0919 on page 2 was dismissed. And 1335 was also going to be reset because it was filed incorrectly.
Okay.
So,
So we go to page 3.
yes, ma'am.
Okay, let's start wherever we're gonna start.
I'm
I
going to
had to
call.
be you the last couple of days, Mr. Nanya, so I'm not gonna try not to step on your toes.
Yes, ma'am. Judge, on first one, I have no one appeared yet. Calling cause number 2024 DCV 4927, Protect Roofing Systems LLC versus EMJ Corporation et al. Announcers, please.
Good morning, Judge. Susan Forbes on behalf of the plaintiff, Protect Roofing Systems LLC. We're ready to proceed.
Thank you. Anyone here on behalf of defendant?
Yes, Your Honor. Charlotte Fletcher on behalf of both EMJ Corporation as well as Hartford.
Thank you so much. So we are here for a scheduling status conference. Unless you're going to tell me otherwise, I'm just going to give you a trial date in 2026 and get our scheduling order entered, unless you tell me everything's resolved.
As much as I'd like to tell you that, Judge, unfortunately, it's not accurate.
What kind of timetable you all want a trial setting in, let's say, like October 9th or November of next year? What kind of timetable do you think you need?
I'm sorry. Go ahead, Charlotte.
Oh, no, I apologize. I interrupted you. Go ahead.
I was just trying to look to see. It's incredible to even imagine that we're setting things out that far.
Joy, yes, you're Miss Forbes, you're speaking to the choir here. Like
Yes.
I'm still trying to grapple with being in November of 2025.
Yes.
I don't know where November went or the rest of the year. So I hear
I
you.
think maybe early November of 2026 would be okay.
Okay.
I don't know if
You all, I mean, you all know best, you know, if you need a shorter timetable, I generally do about a year out. So that puts us in November. November 6th is what I have for early November.
so. What I could tell you is that we're really just getting rolled in this one because the bonding company, who's represented by Ms. Jordan, just answered 3 months ago. So I haven't received their disclosures, so we really haven't even started with paper discovery yet.
So let's use that November 6th target trial date to get our scheduling order together. We have our form, obviously, if you all generate one that mirrors that, in other words, has all the information that's on there, including you all's agreed to mediator, and return it to the court within 2 weeks when we have our entry of scheduling order hearing, then you don't need to appear. If we don't receive that back signed off on by everyone, then please appear for that hearing. And then we'll just go with those dates. If you need a hearing outside of those dates, please make your request with Ms. Hernandez with your file pleading and we'll get you scheduled. Okay.
Judge, will Ms. Hernandez be sending us the form?
Yes.
Okay.
Mhm.
Okay, that's awesome. Thank you.
Thank you so much. Good luck. We'll see you maybe not in 2 weeks. So happy Thanksgiving.
Have a good holiday.
Yes, you as well. Thank you.
Mhm. All right, who's next?
Judge, page 3, calling cause number 2025 DCV 0974, Elizabeth Quintana et al. and versus Nicole Mayers. Announcements, please.
Good morning, Your Honor. Lainey Piercy on behalf of plaintiffs.
Randy Gramling on behalf of the defendant, Your Honor.
Good morning. Let's see. We're set for a status conference. Let me look for your case here on Odyssey. How are we doing? I feel like I've seen you all recently on this one. What's going on?
Yeah, Judge, we got the order to invest the funds, and we had a problem in our office with accounting because the checks were made out to the wrong party by my accounting department. We got them reissued. They were put in the mail today to the court. To the district clerk. Once those get deposited, we can file a notice of non-suit on this one.
Let me see. If I put us out for 30 days, more or less, let's say December 17th for a status conference, we'll use that as our target date for.
Yeah, we should have the notice of non-suit filed by then.
Perfect.
I don't even think we need an agreed final judgment because we already have the order approving the minor settlement. So it'll just be a non-suit.
Okay. Well, I'll set you for the 17th of December.
Okay.
And if we need to be here, we will. If not, we will have it closed out. Okay.
Thank you.
Gramling, you good with all of that?
Thank you, Your Honor.
Have a good morning. Bye-bye.
Likewise.
Who's next?
Judge, next we have the friendly suit. Let me bring in Miss Nissan Cordero.
Okay. Wait a minute on this friendly suit. No, go ahead and bring her in. Good morning, gentlemen.
Good morning, Judge.
Good morning. No, I wasn't here, but I watched it on YouTube. So refresh my memory. What are we doing back? Did we not?
Yes, Your Honor. In advance of the last hearing a couple weeks ago, there was still some dispute between the commission sharing of the co-brokers, apparently. And so at that point, Mr. Winston did not have approval from his clients to approve the settlement. We've confirmed that has since happened. We did the testimony a couple weeks ago.
That's right. That's right. It was on the front end. I did
Yes.
watch it. I can be kind of nerdy like that. I watch hearings, not just my own either. I watch other courts. All right. Thank you so much. And Ms. Valdez, Ms. Cordero, thank you for being here. Let me call it. Calling cause number 2024 DCV 2248, Nisa Cordero and Johnny Galvan on behalf of the minor versus Sunrise Restaurants LLC. May I have announcements, please?
Cole Gum on behalf of the plaintiffs, Your Honor.
Good morning, Your Honor. Moses on behalf of Sunrise Restaurants LLC and Andrea Daniela Rodriguez.
Judge Diana Valdez on behalf of the minor and guardian ad litem.
Good morning. And so we are scheduled kind of as a continuation, I'm understanding, of the friendly suit. Can you all bring me up to speed, please?
Yes, Your Honor. We had a hearing set 2 weeks ago. I think it was the 5th of November. We appeared for that hearing with Ms. Cordero and Mr. Galvan. They did testify as to the approval of the settlement. However, there was still some ongoing negotiation or basically disagreement as to the commission sharing on the structure. That has since been resolved, and I think we're here just to basically approve it all.
Okay, and I thought that I recall, obviously the YouTube is not the official record of the proceeding, but I thought I did hear Judge Rodriguez approve the settlement as it being in the best interest of the minor. And so I haven't seen any proposed documentation or anything of that nature. What is left, I guess?
We filed an agreed. I'm sorry, Your Honor.
That's okay. Just the portion of, I guess, the last I'll call them administrative details.
Yeah, we filed the agreed final judgment. So before the last hearing, we had not had approval to file that by defense counsel, and so we've since filed that. We filed it yesterday and emailed that over to the court. I think that's really all we're waiting on.
Okay, I don't know that I've seen it. So I'll check with Mr. Hernandez. It was still a very busy day yesterday, so maybe I did, but I just
And
want.
I'll confirm it was filed, but I believe it was.
Okay, okay. And just to be clear, Ms. Valdez, everything was still through all of those details good to go, correct?
Yes, Judge. During that last hearing, we did walk through the proposal that I submitted in my ad litem report, and I'll make sure that another copy is sent to you to review. I did recommend that the funds be deposited in an interest-bearing annuity account for the benefit of the minor. Because of the large sum of those proceeds, in consultation with the plaintiff, the minor's mother, we selected an annuity that would provide for a payout over time, with the last payment being made to the minor at the age of 30. And so I was satisfied that ultimately he is going to take a very large investment for his benefit and on his behalf. And we also took testimony with respect to how he has recovered since the incident in question. And so, I'm satisfied that the minor is doing well, that he's an active child. He loves to
popped
help
up
his
on the
mom.
screen, didn't he? He popped up
He did.
during the hearing. I could hear him and then I saw him. So that's all good news. So thank
He
you.
was
Yes,
in the
ma'am.
waiting room for a while with us as well, but then he went back to lie down.
Well, that's all good news. So with that, great, we'll get everything on file so that, and I will verify, but we're good to go. We're good to go on this one. Ms. Cordero, Mr. Galvan, and to your son, I wish you well as well. Happy Thanksgiving. If you all don't have anything else, I don't think I'm going to need to set this for anything else. We're adjourned.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Ms. Valdez. All right. Who's next?
Judge, page 4, calling cause number 2025 DCB 1603 LVNV Funding LLC versus Alma Beltran. Announcements, please.
Miss Carrion Beltran, are you here on this one? No?
No, Judge, that's
Okay, sorry.
when I'm on.
Okay, sorry about that. I saw you pop up. Okay. Do we have do we have attorneys for this one?
No,
Miss-
ma'am.
No? All
don't.
right. Oh, let me go back and look at it. Miss Duran, are you there?
Good morning, Judge. Yes, I'm here.
You know what I'm going to ask you, right?
Yes.
They open their notice.
So I'm not seeing an order setting hearing, but there is a request for hearing. Yes, and that has not been opened by Matthew Clark. I believe he's with Leslie Dodson because he's under the plaintiff's service contacts.
Yeah, so we didn't get a notice out. A notice didn't go out about the scheduling status conference. So let's go ahead and there's a motion for default judgment. Let's go ahead and reset the scheduling status conference with notice to them, Myrna, for January. And then at that time we can see, it looks like folks were served, so there shouldn't be a motion for default. So we'll just do that. We'll just reset it for January.
Yes, ma'am.
Thank you. Okay, that's okay. Who's next?
Judge, calling cause number 2025 DCV 2785 Alma Gasca versus Williamton Savings Fund Society et al. Announcements, please.
Good morning, Judge. Hector Gutierrez here on behalf of the plaintiff.
Morning.
Good morning, Judge. Gabriela Alonso on behalf of Wilmington and Carrington.
All righty. Scheduling status conference as well. Let me get to your case. You all need a trial date, or what do you all want right now? How are you doing?
And I suppose so, Judge. I will say this, we are still working on getting service on one last party. There's about 3 or 4 defendant parties, and the final party we're working on service, and I anticipate having that done very soon. We have our process server working on it right now, is Launch Based Properties LLC. So once that's done, I think we'll be more in a position to know what a good trial date might be. I mean, I'm happy to get one now. and we
Yeah.
adjust it if need be in that way.
Why don't we do one more reset? Because I think I do see that we were set for a scheduling status conference. I guess right after it was transferred back in September, but we'll check in. We're going to come back on the 17th of December.
That would be me, Judge.
17th of December at 10 a.m. for a scheduling status conference, and hopefully everybody's here.
Thank you very much, Judge.
Thanks so much. We'll see you next time.
Thank you, Judge.
Thank you.
Have a good day.
Thank you,
All
Judge.
right. Who's next?
Judge, for the next one, let me bring in Mr. Gabriel Gutierrez.
And I think I did receive. That's where you're here, Angie. All right. DCV 2087. Angie, did I receive a report? Did you send one?
I did. I filed an original and an amended ad litem report September 16th. It was e-filed.
Okay, I see. Okay, thank you. All right. Head, Mr. Nunez.
I'm calling cause number 2025 DCV 2087, Gabriel Gutierrez et al. Versus Melissa Aguilar. Announcements, please.
Oh. Are we missing an attorney?
Maybe missing defense counsel.
Yeah.
Yes. Mr. White or Mr. who had appeared also, Mr. Grambling.
Ms. Grambling was on earlier and left, Judge.
Yeah, but are they still at this? I don't know. Okay, well, we need to get somebody back.
Yeah. Sebastian Uribe also appeared on this one.
Yeah, and he's gone
Sean.
too, right? Right, like he moved firms.
I'm not sure if Sebastian moved. I know Mr. Grambling and Mr. White.
Yeah, I know Randy did.
Yeah. Okay, so I'm sorry, excuse my ignorance. What is the law firm?
It is now the firm.
But
It's
they were
based out of the Ainses. I think they're of counsel with Frank Ainsa.
okay, but this is Kemp Smith, right? This is
Kemp Smith.
Kemp Smith's case.
Correct.
Maybe we can call Mr. Grambling, Mr. Nunez, and see who, if he has kept this case or if it's still with Kemp Smith. And if so, who is going to appear from Kemp Smith? So we're going to need a minute.
Yes, ma'am.
We'll get started as soon as we get defense counsel here.
Hello. Hey, Matt.
Hey, Randy, how's it going?
Good. Had we got the judgment entered in on this case yet?
No, today's the friendly suit hearing.
Okay, I'm gonna let you all. I'm not prepared, so I'm gonna let you all take the lead.
Oh, yeah, no worries. It's pretty straightforward too.
All right, are we ready now?
Yes, Your Honor. Sorry about that.
That's okay.
Yes, yeah.
No worries. All right. Okay. Calling cause number 2025 DCV 2087 Gabriel Gutierrez on behalf of minor child versus Melissa Aguilar. May I have announcements, please?
Yes, good morning, Your Honor. Matthew Lopez for the plaintiff Gabriel Gutierrez on behalf of the minor child, EG.
Angelica Carrion Beltran on behalf of the minor child as ad litem.
Randy Grambling on behalf of the defendant, Your Honor.
All right, and we are set for a friendly suit. Mr. Lopez, you may proceed.
Thank you, Your Honor. We'd like to call Mr. Gabriel Gutierrez.
All right, Mr. Gutierrez, if you would, I do see you here on the screen. If you would unmute, please. And then I'm going to go ahead and swear you in. If you would please raise your right hand. Sir, do you swear or affirm any testimony you provide will be the truth and the whole truth?
Sir.
Thank you very much. You can go ahead and put your hand down. Let me just have you state your name so I can test your audio, make sure we can hear you.
Can you hear me?
Yes.
Yeah.
Would you state your name for the record, sir?
Gabriel Gutierrez.
Thank you. Mr. Lopez, you may proceed.
Thank you, Your Honor. Good morning, Mr. Gutierrez.
Good morning.
Are you a parent with custody of the minor that's involved in this case, Elijah Gutierrez?
Yes, sir.
And Elijah is your son, correct?
Yes, correct.
How old is he?
He is 15.
And you understand that we're here today on behalf, in regards to a car crash that occurred on July 8, 2023 that involved you and your son, Elijah, correct?
Correct.
And that car crash kind of makes the basis of this whole lawsuit and why we're here, correct?
Correct.
And in that crash in July, is it your understanding that you were stopped at a stoplight on Gateway near Eastlake when you were rear-ended by another vehicle, correct?
Correct.
And the driver of that vehicle, Melissa Aguilar, is the defendant in this matter, correct?
Correct.
And as a result of that crash, you suffered some injuries, but your son suffered, Elijah suffered injuries, correct?
Correct.
And some of those injuries, and the main one was really a fracture to his right arm, is that correct?
Yes, correct.
And he had some other bruising and minor injuries, but the main injury was the fracture.
Yes, correct.
And that required some treatment, and Elijah had to be seen at the emergency room and eventually by an orthopedic doctor, correct?
Correct.
And they didn't have to do any surgery on the fracture, is that right?
Correct.
They placed it in a cast?
Yes, correct.
And then the doctors monitored Elijah throughout the time in the cast and eventually removed the cast after about, was it 6 or 8 weeks or so?
Yes, correct.
And after they removed the cast, they took a look at him and everything was healed. What was the end result of the treatment?
Yeah, everything was good.
And Elijah didn't have any other follow-ups or any other kind of treatment after being released from the orthopedic doctor, is that correct?
Correct.
And after the crash, it wasn't until February of this year that you sought counsel, and you sought our services for counsel to represent you and your family for this crash. Is that correct?
Yes, correct.
And we began representing you all and Elijah, and we were able to negotiate with the defendants and reach a settlement. Is that correct?
Correct.
And you understand that we're here today to ask the court and going to review that settlement with the court and ask them to approve that settlement that's been offered on behalf of Elijah, correct?
Correct.
And it's your understanding that the settlement that has been offered at this time is $30,000, correct?
Correct.
And that is the per person policy limits as we understand it from the defendant's insurance, correct?
Correct.
And so you understand that if the court approves that settlement for Elijah, that some of that money would have to be used to pay my attorney's fees. There's some costs associated with the case, and then the remaining funds would be a net to Elijah, correct?
Correct.
So specifically, you understand that our attorney's fees are $10,000 for this matter, and we reduced those from the contract that you originally signed of that was 40%. We reduced that down to 1/3 at $10,000. Is that correct?
Correct.
And that $306.44 would also need to be paid as far as cost and associated with prosecuting this case on behalf of Elijah, correct?
Correct.
And then you understand that Elijah's treatment, although it was covered by Medicaid, legally, it's your responsibility to make sure that Medicaid gets paid back for the services and the treatment that they provided to Elijah, correct?
Correct.
And that amount totals $1,434.97, correct?
Correct.
So after paying everything that we just discussed, attorney's fees, cost, and Medicaid, the net amount that would go to Elijah in this matter is $18,258.59, correct?
Correct.
And you understand that, Elijah being 15 years old, that money isn't paid to him today, that the money would be held until he is of age of 18 years old as an adult, correct?
Correct.
And being his father, you looked at all the potential options of what could potentially be done with that money for his benefit. And ultimately, you decided on an annuity for your son. The money would be invested into an annuity for your son that would pay him out over time, correct?
Correct.
And that annuity that you chose, as they call it, the four-year college plan, is a plan that would start paying your son at the age of 18, and he would receive 2 checks a year, so biannually, for 4 years, correct?
Correct.
And the amount of those checks would be $2,570.63, correct?
Correct.
And again, he would receive 2 of those checks each year, correct?
Correct.
And so at the end of those 4 years, after his full payment, the amount that he would be netting would be $20,565, correct?
Correct.
And when we looked at it closely, it's about a 2.69% interest rate return for your son, correct?
Correct.
And you understand that's guaranteed money, and that's how the annuities work, correct?
Correct.
I understand that it's also an additional protection for your son because it helps kind of protect the money from him, and potentially the other option would be to give him all the money at the age of 18, correct?
Correct.
And as his father, you decided that you would rather him receive the money, in stages in that 4-year period, correct?
Yes, correct.
Now you understand too that if the court approves this settlement, this is the only monies that your son could ever receive in association with this crash, right?
Yes, correct.
And that you all as a family weighed out all your options, and we discussed it as far as settling the case or even potentially going to try the case in front of a jury, and you guys understood that you would, or understood all that and would prefer to settle the case, correct?
Yes, correct.
And you believe that by settling the case that this is actually in the best interest of your son Elijah, correct?
Yes, correct.
And you're here today asking the court to approve the settlement.
Yes, correct.
I'll pass the witness.
Mr. Grambling, do you have anything?
No, Your Honor.
Ms. Carrion Beltran, you may proceed.
Thank you. Good day, Mr. Gutierrez. Just to clarify or to inform the court, Elijah's been able to resume all of his regular activities, correct?
Yes, correct.
And that includes being able to play football this last fall season for Fabens High School, correct?
Yes, correct.
And you do not anticipate the need for any future medical attention for the fracture he sustained, correct?
Yes, correct.
Thank you. And I pass the witness.
Thank you. Anything else, Mr. Lopez?
Nothing further from us, Your Honor.
Okay. Thank you, Mr. Gutierrez. Mr. Lopez, do you have any other witnesses?
No other witnesses, Your Honor, and I believe we have we can submit a proposed judgment to the court outlining all of that, if it hasn't already been emailed to the court coordinator.
Okay. All right. Ms. Carrion Beltran, do you have anything else for the court? I did review your report. I think everything I heard was consistent in terms of the testimony today coincides with your report. Is it your recommendation that the court approve this?
It is, Your Honor. It is my recommendation. The only thing that has changed since the submitting of the report was my ad litem fees.
Okay.
They've now, I double checked with my accounting system and they're $1,950.
Okay. Per the last report, I see that Allstate is covering the ad litem fees. Is that right, Mr. Grambling?
Yes, Your Honor.
Okay, so the court will find that the settlement as proposed with that updated ad litem fee, the settlement proposed is in the best interest of the minor in this case, so I will approve that. I will also approve the updated ad litem fee at this time. Mr. Gutierrez, I wish you and your son very well. Happy Thanksgiving. As soon as I receive, I didn't do a quick search of my emails, but as soon as I see the documents, I'll sign off on them and get everything filed as they're supposed to be with the court. Okay?
Thank you, Your Honor.
Thank you very much. Thank you for your time. You all are excused.
Thank you.
Thank you, Your Honor.
Happy Thanksgiving to you as well, Judge.
Take care. All right. I see Mr. Blumenfeld, and that is on 0600. Are we at 11 o'clock? And I think, is it McGinnis Law? Oh, no, they're not here on 2. They're here on the next case. What we're going to need to check, Mr. Nanez, on 0600 is if anyone is here on behalf of Meraki Solar, because
Mr. Beltran was here, Judge. I don't know where he left.
he withdrew last time.
Yes, ma'am.
I granted his motion to withdraw. So let me go back to Meraki. Let me look that one up. Mr. Beltran withdrew. I don't know if we have an order, but I granted it on the 12th of November. And if I'm not mistaken, the summary judgment was already set. So I don't see anything in terms of a new attorney on behalf of the defendant. Mr. Blumenfeld, has anyone gotten in touch with you from Meraki? I can't hear you for some reason. You're not muted.
Sorry about that.
That's okay.
Okay. Your Honor, I call them Marikai, but maybe it's Meraki. That company is
Gone.
essentially defunct. They're in a Florida-based liquidation proceeding, and so I don't anticipate they will respond, but I had been told by Mr. Beltran that they weren't going to defend this case, and so we were just gonna. This is a case where they left a lease early, They're not disputing they left early. There was a breach. They didn't even dispute the amount of damages that the kind of lease damages calculation that we provided. And so for purposes of today, we were just going to ask, for the court to grant the summary judgment. It may or may not be collectible based on what's going on in that liquidation proceeding in Florida.
Okay. Okay.
And he did submit an order. It was unopposed to withdraw. I think it was signed and filed, but I'd have to look.
I feel like I did, but I would have to do the same thing while we're waiting. I guess I can do a quick search here. Let me see. Because I remember the discussion. Let me see, DCB 0600. And I know I had reviewed it. Oh, yes, I received it and I didn't sign it. Proposed order granting. The day of, there it is. Whose signature is that? Wow, that's a signature. Okay. So, Mr. Blumenfeld, had you provided a proposed order on your summary judgment?
I've got the motion in front of me, but I don't know that I did that. I'm checking right now. I could definitely email you something, right after this call.
Okay.
One way or the other.
We are going to call it. I was just making sure. I remember when I reviewed, I failed to sign the order 2 weeks ago, but I remember I reviewed it and was certain that we did have, sometimes on those motions to withdraw, we don't have all the details, but Mr. Beltran was very thorough in adding all the hearing dates and all the information. I think he even had the Zoom ID in there to make sure that if they wanted to appear for this hearing, that they would. So we're going to call it. And the only thing I will ask of you, Mr. Blumenfeld, is that you provide me after the hearing with the proposed order. Okay?
Yes, Your Honor. We will get that to you right away.
Okay, so let's call it 2025 DCV 0600 Sunland Business Center Partners LP versus Marikai Solar LLC. May I have announcements, please?
Robert Blumenfeld, I'm here on behalf of the plaintiff.
And we are set for a summary judgment hearing today. As we were discussing briefly off the record, Mr. Beltran, prior counsel for defendant, was allowed to withdraw on November 12, 2025. And as the court noted at the time of that hearing, that all hearings were listed to include all Zoom access information to the entity, the defendant entity, to be present at today's hearing. I don't see anyone in the waiting room. And just to be clear, Mr. Nanias, we haven't had any contacts from anyone on behalf of defendant in this case?
No, ma'am.
All right, so you may proceed, Mr. Blumenfeld.
Yes, Your Honor. I represent the plaintiff, Sunland Business Center. They own a commercial strip mall on the west side of El Paso off of Sunland Park Drive, and they leased a commercial space to Marikai Solar. Marikai breached the lease. There was never a dispute that they breached the lease by departing early, nor was there ever a dispute in this case over the landlord's calculation of the lease rental and related damages. And there was no answer filed. And so we were asking the court to grant the motion for summary judgment, which had been filed after time for written discovery in the case. And it's supported by a declaration that I provided just to prove up the records.
And I believe that was filed separately as part of the court file. Is that correct?
Yes.
Okay. Anything else?
I can just say that the plaintiff originally sued for over $40,000, but they reduced the amount of damages, and they asked for in the motion $23,989 for their breach of lease damages and $33,609.58 in legal fees and court costs. And then legal fees and $504.81 in court costs. And that's what will be in the order that we send, Your Honor, if you are to grant the motion.
Okay. That, anything else?
No, Your Honor.
Okay, so the court will accept, has reviewed the motion, and the attachments will take judicial notice of all the documents in the court's file. The motion for summary judgment is granted. If you would please provide the order to the court, we can get that on file.
Okay, we will get that to you today.
Thank you.
All right.
Thank you.
Anything further, Your Honor?
No, sir.
All right.
Your excuse. Bye-bye.
Thank you. Bye.
All right, so the only one we're gonna have left is at 11:15, so we're about 10 minutes early.
Hello, Mr. Jones, are you there?
Hello, good morning.
Hi, are you here for Bike Dreams?
Yes, I am.
Who are you here for, the defendant or?
Yeah, I'm one of the lawyers for Lumen, a non-party. And my colleague Michael Cabot is here as well.
Okay, we'll be with you shortly. I think we're still missing someone from. Because that's up for the 4 minutes, so.
All right. Thank you, sir.
You. Hello, Mr. Sher.
Can you hear me?
Yes, sir, sure can.
Hey, good morning. How are you?
I'm well, sir. Yourself?
Doing fantastic.
Are you here for Bike Dreams versus BP Real Estate?
Yes, sir.
Great. Thank you very much, sir. We'll be with you shortly.
Thank you, sir.
Mr. Nanez, are you there?
Yes, ma'am.
So I know folks have been waiting for a minute. Are we expecting Mr. Fuel?
No, ma'am. I believe
No? Okay.
everyone's here.
Okay, then let's get started. Walter, are you ready? Let's go, Mr. Nanez.
Okay, yes, ma'am. Calling cause number 2024 DCV 2991 Byte Dreams Group LLC versus EPT Real Estate Inc. Announcements, please.
Your Honor, may it please court, this is Jim Scheer on behalf of the plaintiff defendant in this case, EPT. Mr. Shane just notified me he's in another hearing, is not going to be able to attend.
Okay, and that was my other question. I said Mr. Fuel, but I also meant Mr. Fuel, but I really meant Mr. Shane. And so thank you for updating me on that one because I know he was present at the last hearing. All right, go ahead.
Michael Cabot along.
I could not hear you, so if you'll try that again, please.
Sorry, Your Honor, Michael Cabot and Austin Jones on behalf of non-party Lumen Technology Services Group.
Okay, and we are set today on the motion nunc pro tunc and motion for leave. I guess a request on the rehearing on the motion for leave. Mr. Scherer, you may proceed.
Yes, Your Honor. On October 1st, we had a hearing with this court on a motion to permit us to leave to file amended lawsuit and add in Lumen as a defendant. At that hearing, the Lumen argued that you had entered an order that resulting from a hearing that we'd had back in August, and in the order that they presented to you, they said that that order required us to file in a separate cause, and that they were not required to answer any further. We learned of that argument shortly before the hearing. Both Mr. Shane and I were shocked because neither of us had noticed that language put in an order which you never announced, never said, never presented in the hearing, where you said very clearly that our motion was for leave in August had been denied because we didn't give them notice. But you did, and you said it was without prejudice to us filing suit again or bringing the case. So we had filed a motion for leave to allow us to do it. And that hearing that you had October 1st was really the first time that we learned that extra language had been added to the order. So both Mr. Shane and I went back to research what happened. We found nothing to indicate that you had ever said that. And what we found was a repeat of what happened on the hearing you had October 1st. On October 1st, after the hearing, Lumen's counsel sent you a proposed order just to sign. They didn't send it to us. They sent it straight to you. And it had that same type of language in there that they put in the first one. I spotted that immediately because I was paying attention to what had just happened. And I objected to that proposed order, and we cleaned it up, and it was submitted in proper form with us agreeing, approving the last order from October 1st hearing as to form. So when that came up, it became apparent to us that we needed to bring it to your attention because we have rules in court in our district here and most every other district that says before an order is presented to the court to be signed, it's supposed to be submitted to opposing counsel to be signed off as to approve the form or not. Had that August 13th order been submitted to us, we would immediately have spotted that self-serving language that was put in by Lumen, and we would have objected to that. And frankly, I think the court would have, well, I don't know what you would have done, but at least we would have had the opportunity to say, that's not right. That's not what you ordered. That's not what was discussed at the hearing. And we'd like to object to that form of order that the defendant submitted to you frankly, without notifying anybody on it except sending it to you. So that's why I prepared and with Mr. Shane this motion nunc pro tunc. It's a very unusual thing. Among, I don't know if the court's dealt with them before, but basically it's a motion nunc pro tunc, which means we're going to go back as it was and fix mistakes in the order. And we submitted to you in correct form a proposed order nunc pro tunc. So you do remove out this language that was added in without being stated on the record by you or presented to you, definitely not presented to us or discussed with us, but was presented to you just to sign. Now that's one of the reasons that the court and every judge in our district here in El Paso requires both parties to sign before submitting it to the judge. So we would ask, one, that the court grant our order nunc pro tunc, and then second, bring it, because one of the main reasons you denied our motion for leave to add lumen in this case was because of that language. And let me explain why they need to be added to this lawsuit. EPT is suing Lumen and Webitron. Webitron was a tenant in the building owned by EPT. EPT leased a small office space to Lumen, not to Lumen, to Webitron. They paid like $400 a month. Well, what happened is Webitron, without approval or agreement and in violation of the lease, went and tapped in to the power of the electricity that EPT was paying and used that to process their internet business, that they provide internet service like Spectrum does to customers. And they contracted with Lumen, who went in and tapped into EPT's electrical system. Again, we're and put equipment in one of the electrical closets in the building without EPT's approval or agreement. They just did it and ran their business together, where Lumen was charging Webitron, and Webitron was charging its customers, and they were using the electricity that was being paid for by EPT, so that every single month the electric bill was higher than what even Webitron was paying in rent. It kind of reminded me of the concept that took place when teleprompter first came to El Paso, and people were going in on cable service and splicing into the cable television service so that they could get free cable TV in their house and use it without having to pay for it. And teleprompter went out and went after the people who were doing it. And I think there's some criminal statutes that apply to that. This is not a criminal case. This is a civil case for damages to get paid for the electricity and the damages that EPT suffered by reason of both Lumen and Webitron together teaming up and, frankly, converting the electricity that was being paid for by EPT. So those are our two items. One, fix the order. It should have been presented properly. And two, permit leave to amend the lawsuit to put Lumen in this case so the two parties on the defense side can be presented for what they did together. That's it. Thank you. Do you have any questions?
Of you, Mr. Chair? No. Ms. Hernandez, are you there? So I want to be clear on this matter on the order and the circulating of the order. It's correct.
Yes,
when I ruled on the request previously, I did request a proposed order. And so I want to be clear now so it is never unclear and as this case goes forward. As I rule in that manner, in other words, not at the time of hearing after I've done my review of your arguments and your pleadings, when I rule and request an order, Ms. Hernandez, please make sure that when we convey to the attorneys to submit a proposed order that it includes the instruction to circulate amongst all the parties. Okay? So
Yes,
with that, I have an October 2nd, 2025 order denying defendants cross plaintiffs EPT Real Estate seeks motion for leave to file amended cross claim. Let me understand, is there any issue with that order?
The October 2nd order is what I signed off on, Your Honor, and I have no objection to, we're not bringing that forward because that order was fixed before it was submitted to you to sign.
And let me be clear, the motion, let me go back. Motion for judgment, nunc pro tunc. Let me pull that one up really quickly. Okay, so am I understanding correctly, Mr. Scherer, that the motion nunc pro tunc to modify order dated August 13th, that was filed October 30th, is the October 2nd order, I guess, curing your request in the October 30th motion? I think
No,
I'm failing
no,
to
no,
understand.
no.
Can you explain that to me again?
Yes, Your Honor. So you've had two hearings. The first hearing involved the motion for leave, the motion to for leave to add Lumen as a defendant. That was in August. And the defense argued that it should be denied because they were not given notice of it, of our motion for leave prior to the filing of it. And they argued under Rule 40 that we didn't follow the rules. We disagreed with that, but the court determined that our pleading should be stricken and that we, as to bringing Lumen in, but it was out without prejudice to us adding to refiling it or suing Lumen. That's the order that we are asking to be corrected on the nunc pro tunc.
What's the date of that order? Because I do see that you attached a proposed corrected order, right, to your motion?
I did, yes, Your Honor. It's
Okay.
Exhibit A.
But where is the previous order, if you'll help me there?
I don't have that attached.
That's an August 13th order, is that right?
Yes, Your Honor, and I'm sorry, but I would download it and send it to you if I knew how to do it.
I
Sorry.
don't see it. My question is, there's not an entry in the court file for August 13th as an order. Could the date be something different?
Bear with me, please.
Ms. Hernandez, do you see an August 13th order in this case? Or Ms. Duran?
Judge, you should actually, I was going through it, you should be able to find it in the disposition tab. It's right in between causes and financial.
Okay.
I believe that's why it wasn't showing on the events.
I did find it, Your Honor. It was filed on August 13th, 2025 at 2:29 p.m. I don't know how to.
The clerk has directed me. It's not in the list of where I expect to see everything. It's kind of in a separate folder and a disposition folder. So let me open that one. Okay, there we go. Let me just print it. And that's where I was getting stuck because I didn't I know that didn't come from nowhere. There was something, but it wasn't loading up on my events. So let me just print it so I don't have to deal with the electronic copy. Okay. Okay, so the August 13th order. Okay. And so your proposed, now let me go back to your motion. No pro-tunc. Proposes okay. All right, go ahead, Mr. Sher.
So that you can see now, looking at the August 13th letter order, that the second sentence should have stopped at the word that are here. The citation directed to Lumen is hereby quashed, and EPT's claims against Lumen are hereby dismissed. Should have been a period right there, or without prejudice. Period. And then they added in the language to refiling in a separate cause. That was never discussed. The next line was never discussed.
They're relieved of any obligation to answer?
Yes.
Okay.
That was never discussed either. Now, obviously, when you dismiss the citation, then they don't have a duty to answer. However, that wasn't part of your order. The only thing that you did is you just said, I'm granting Lumen's motion, I'm denying your leave at this point, and but you have the right to refile it. That was it. And it's important for me to bring this to your attention because I and Mr. Shane and Mr. Fuel practice in your court and will for years to come. And it was pretty obvious in the last hearing that the court felt like we weren't following your rules and weren't following what you told us to do, and denied that motion when we came back and refiled it on motion for leave, following what we understood you ordered to come back and deny our motion for leave, which we thought was very appropriately handled. We went back and dealt with the rules on it. Even my appellate attorney, Mr. Ward, had looked at the filings and prepared the draft, said, it's done right, but this time it's good. And when they pulled this order of August 13th and put it in front of, said that you dismissed it, but it had without prejudice, but it had to be refiled in a separate case, a separate cause. That's where you denied our motion for leave. And that's why we came back and researched this background of what was done in this order that was different from what you ordered and what was said in the record. And why this order should have been presented to us rather than submitted directly and signed by you.
Here, let me stop you just so I can make sure I understand. And on this nunc-pro-tunc, sometimes when I print things on Odyssey, if there are attachments that are voluminous, either they won't come out in the initial printing or separate. Do we have the record for that hearing? Did you review the record?
No, Your Honor, do not have the record.
Okay. All right. Well, okay. All right, what else?
That's it. Do you have any other questions for me?
No, I do not. not on the non-proton. Can we start there? I don't know, Mr. Cabot or Mr.
I
Jones.
would love to have an opportunity to respond to all that, Your Honor, if you'd like.
I want to start in order. So I understand,
Sure.
Mr. Chair, you put both your requests kind of in one argument, but I want to make sure I understand. So I'm going to start and ask Mr. Cabot to respond initially on the NUNC, please.
Sure. Your Honor, thank you. And I want to start off by recognizing that when I submitted the August 13th order, I didn't seek approval as to form. And I apologize to the court and Mr. Sheriff for failure to do that. What happened, as the court may recall, is there was no ruling from the bench or oral pronouncement at the August 6th hearing because EPT hadn't filed a response in opposition at the time. And so the court allowed Mr. Scher to file a response after the hearing and said it would take it on submission. And I agreed to that. So you made no ruling or oral pronouncement at the August 6th hearing, contrary to what Mr. Scher represents in his proposed order into you, because you took it under advisement. And what happened is a week later, I got an email from your court administrator asking to submit a proposed order. And I did that. And that email is attached as Exhibit A to my response. And I called out in that email that the order was without prejudice to refile in a separate suit because I wanted to make it clear that we weren't trying to get a dismissal with prejudice. Now, Your Honor, a motion for nunc pro tunc is to correct a clerical error in a judgment after the court's plenary power has expired. There's no final judgment here, and there's no clerical error, respectfully. And there's 3 reasons for that. The first is the order tracks the request for relief in our original motion to quash that was filed. In the original motion.
Okay, you're about to tell me. I was going to say, can you be specific?
Sure. In the request for relief of the original motion to quash, it states that Lumen is relieved of any obligation to respond to this matter. That's in the request for relief for the motion. That language is in the last sentence of the October 13th order. It tracks. Okay. Second, the order is consistent with what I argued at that hearing, which is they can file a separate suit against us if they want, but we believe it's improper to have us joined in a landlord-tenant dispute that's been on file for a year when there was a jury setting pending, and the claims against my client are different from those against the landlord-tenant, which sound in contract, and there's a separate regulatory scheme. So it would prejudice us, it would confuse the jury. The third reason why there's nothing wrong with the order, and this is attached as Exhibit C to my response, but opposing counsel emailed me when I was trying to confer before the very first hearing, as to a new scheduling order. And they told me, well, if your motion's granted, we'll just file a lawsuit against you in a separate suit. Okay, so that's Exhibit C. And so the order I submitted where I called out that language was to make clear they could do what they said they were going to do and consistent with what I argued. All right. And so for those reasons, there's nothing to correct. And I apologize for not seeking approval as to form. And I'll guide myself accordingly going forward. But in the sake of transparency, I believe the order honestly and accurately reflects the relief we requested and what we argued and what we were told would happen. Now, counsel suggested that they hadn't seen this August 13th order until the second hearing in October. Attached as Exhibit B to my response is the court's delivery of that order on August 13th to Mr. Scher, myself, Mr. Shane, and everyone else. And so it's surprising to me how they could claim that they never knew about this order when the court distributed it to everyone on August 13th. And so that's what happened at the first hearing. And that's why I believe the motion for nunc pro tunc should be denied, because there's no clerical error that needs to be corrected in that motion. Now, the second thing they argue is that you should rehear the October 2nd hearing. In that hearing, Mr. Scher filed a motion for leave, which he didn't do in the first hearing, and he sought leave to add us as a cross defendant in that case. And we filed a response, and the response said this is contrary to what the August 13th order states. And we also made additional arguments about how, regardless of what the order states, we believe it would be inappropriate because the nature of the claims are different than those between the landlord and tenant, and there's a separate regulatory scheme that applies. So it would confuse the jury, unfairly prejudice my client. And the court heard all of those arguments, and there was no argument at that time about whether the August 13th order was correct or not. So the court ruled from the bench on that one and said it was denied. And we submitted a proposed order to the court, copied opposing counsel. Mr. Scher objected to it. We worked with him to accommodate that. And so here we are a third time on this. And I would respectfully ask that the court rule consistently with the way it has the first two times, and that there's no error to correct here. That they remain free to file a separate lawsuit against us if they want, and we contend that would be appropriate. But as far as going back and undoing the first order, and then I don't know, I guess reconsidering and ruling the opposite way on your second order, we don't believe is appropriate. You are well within your discretion to grant Lumen's original motion to quash and enter the order you did, given the circumstances in which we were attempted to be joined as a party. And so you're well within your discretion there, and there's no error to correct. And, I take issue with the way Mr. Scher's proposed order is drafted, because it presupposes that you ruled from the bench at the original hearing and made certain pronouncements that didn't occur. You took it under advisement. The response was filed shortly after the hearing. We filed a reply. I think they filed a surreply, and then we got the request from the court administrator to submit a proposed order granting it, which we did.
Okay. Mr. Scher, do you have a response?
Yeah, I do, Your Honor. First, they make technical argument that we did not give them, did not seek leave of court to begin with, to file the lawsuit. And you sustained that objection after you heard it. But they put in the order this language that we have to file in a separate lawsuit. And then the last hearing, they come forward and use that language to convince you to strike our motion for leave. That was inappropriate. They didn't handle the first order correctly at all. Not even attempt to run it by us. Apparently just submitted directly to you to sign. And then use that to bootstrap the argument to say, you're not allowed to bring it in this lawsuit. So when you heard that in October, you just turned us down flat and said, no, we're not going to have it in this case. Well, now they're coming back and saying to you, well, you're right. The order doesn't reflect what you ruled, Judge. It reflects what we wanted And we added extra language in there ourselves because that's what we put in our motion. Well, that was not hard for them to submit that to us. Now, why does it need to be in this case? It's not just a landlord-tenant issue. It's involving conversion of electricity, trespass, going beyond the terms of the lease by both Webitron and by Lumen, who did not have any rights to be in the building except their contractual relationship with Webitron. So they're the same parties, the same transactions, the same witnesses, the same evidence, the same claims result for both of them, because the electricity being used by Webitron through Lumen and Lumen directly by hooking into the building are all part of the same damage model that EPT suffered as a result of both of them going under the trespassing, converting the property. Yes, there's a claim separately for breach of contract with Webitron, but there's also a claim of tort claims against both of them, because those are not contractual. Those are based on torts and intentional torts. Trespass and conversion are both intentional torts. And both of those torts resulted from Webitron and Lumen together going and taking electricity that didn't belong to them, using it for their own benefit, charging their customers for it, and sticking EPT with having to pay the electric bill. And the reason it's brought together is because it's not a nominal sum. They had a lot of equipment. They had antennas on the roof. It was the way it worked is that Lumen had a processing unit, the two of them, that were each using apparently 25, I don't know, kV, I think is what it was. I'm not sure. It's the electric usage is 25 per each unit. And they were using that to process the electricity for the 6 antennas that Webitron had put on top of the building. As you look across, if you have a cell phone, for example, and you have Verizon or T-Mobile, and you have cell phone towers with antennas, that's the type of antennas that were put on top of EPT. They were satellite-oriented antennas that were processing internet for Webitron, and and Lumen and was providing the processing units to process the signals that were coming off of the antennas on the roof, which would then wire straight into the unit that into the equipment in Webitron's space in the small unit they rented in the building. And then Webitron would bill their multitude of customers for internet service like Spectrum or AT&T does. So those two together are combined in their usage of the electricity for a combined purpose and a combined profit and a combined business. That's why they need to be together in one lawsuit. And so we would ask the court simply, 1, to correct the order, 2, to grant us leave to add Lumen in this case.
Thank you. I don't need to hear any more argument today. I am going to review the pleadings and everything else I need to review, and I will have a ruling for you before the end of the week. Thank you very much. Have a good day.
Happy Thanksgiving to you.
You too. Bye-bye.
Thanks.
Mr. Nanez, is that all for today? Thank you very much.
May we
Yes, ma'am, that's everything.
You may. Have a good day.